All right. Good morning, everybody. And
Morning.
welcome to Lexia Growth webinar to hear about data protection matters and other related up-to-date checks and some basics. I'm Markus Myhrberg. I'm a partner at Lexia and also heading our Lexia's growth program. And this webinar is also organized in cooperation with Upgraded. So welcome everybody from the health wellness sector and all other webinar attendees this morning, and we will have a quite effective and very brief but lot of matters this morning. Hope everybody's enjoying. And with me here is Ville Kukkonen. Please, Ville.
Hi, good morning also on my behalf and welcome to this webinar. I'm Ville Kukkonen and I work here in Lexia as a senior associate in our data protection practice.
Yeah, and actually Ville already said here the agenda for today. So as briefly mentioned, we will go through some key elements in the compliance and accountability questions. I always say it's a elementary question and matter to actually remember the basics. You can't play with the details if you do not remember the basics and the bases of data protection regulation. We do not go too in details, but like some of the major points which affect also the cases which show up in the cases to be go through today, and also, for example, regarding the transfer of data out of the EEA. And after these key elements, Ville will go through some recent cases, mostly from some examples from globally, but mostly from Finland, the Finnish cases. During the last year, we got a few interesting cases, and now it's time to a little bit analyze those and like go through what was actually behind the cases. Now, these are the cases from data protection authorities which are already solved. And then the third part is the still actual question about the transfer of the personal data out of the EU EA. So what's going on there? This has been a little bit a moving obstacle from since last summer, what we call Schrems cases and nullifying the privacy shield mechanism, for example. But that's the third part of this morning's webinar. So please, you can send your questions by the chat or questions, also using the Zoom tools, and hopefully, if you want possibility to ask a question also online, but maybe easiest to write the questions, and we try to save some time in the end to go through the questions. Yes, so let's go and have some key elements and the protection matters. Today we talk mostly about GDPR questions, so General Data Protection Regulation, and all that regulation which covers the most important questions of the data protection scene. I always have to say that because it's asked, so nowadays since 2018. In a few months about 2 years. 3 years ago, sorry, 3 years ago, about to say. So we have had GDPR being the main regulation on these matters. Today we don't go through too carefully through what is personal data, etc. That's a question about other webinar, but of course, we get some examples. But since the beginning, it's good to remember that the definition of personal data is quite wide. So whatever which can be connected directly or indirectly to a certain person can be considered to be personal data. So that's from the names and addresses to email addresses, IP addresses, and in some cases, and in most of the cases nowadays, also cookies are, for example, considered to be personal data. At the same time, they are tracking tools. Today, we do not touch the question of cookies and other tracking tools, which is very important and also a little bit moving all the time. And just to note in the beginning here that cookies and tracking tools are partly governed also by GDPR, but regarding those, there is a regulation called e-privacy. And at the moment it's a directive, but there will be a e-privacy regulation. And if you are interested in and more like technical questions about the data protection, e-privacy regulation is the legislation where you can find answers to cookies, etc. But of course, these two are combined at the end of the day. Just to note, like the small difference between there. And actually, this shows in the regulation which applies in Finland. In Finland, in addition to GDPR, which is in effect as such, governing Finland and the other EU countries. So we have Data Protection Act, which includes certain points. And for example, from Data Protection Act, you can find more defined rules regarding the legal basis of processing in certain cases. And one question which is always raised up is that, for example, the personal identification number or code, that regulation is included in the Data Protection Act. Then what we have actually taken here is the Act on Electronic Communication Services, which is more based on e-privacy actually. So not GDPR, but it's kind of part of the game here and should be taken also into account when we talk about personal data and processing personal data in technical environments. Then it's good to remember we do not touch, but it's good to remember that we have also all kind of sector-specific legislation in the finance industry and of course in the health industry regarding personal data, where, for example, in health industry we have had, or health sector, we have had like for tens of years already certain regulation, for example, on the patient information, etc. And that's like sector specific, which should be always taken into account in addition to these general laws. And just to mention that regarding HR and the working life, there we do have a very specific law in Finland on the protection of privacy in working life, which is kind of bit specific in all Europe. I think that there might be in a few other countries there is a special law on that. But that's like a little bit on the background, just to remind what we do have. Yes, Ville. And then we just wanted to emphasize a few things here. which are the principles related to processing, which should always apply. So there are two things: the principles and the kind of general principles which should apply always, and in addition the legal basis for processing. We talk about these two. And today this slide was just about to remind what are the key elements of key principles. And of course, I always point here certain matters which should lead to the end that at the same time you can be in compliance with the processing rules and also able to demonstrate the compliance. We will few times perhaps maybe mention the accountability term. So, and at least regarding the documentation, and it's good to remember that it's not enough that you comply with the laws. You have to be able also to demonstrate the compliance with certain documentation, etc., etc. But regarding the principles, key elements I would say here is, of course, that it's according to the law, but transparency. So, and those are for example, the information obligations under the GDPR. So you have to tell clear enough in your privacy policy or somewhere else how you process the data. And this is one of the key elements I'm always emphasizing, that to let the data subjects know how you actually process. Where it comes, where it goes, which information, for what purposes you use, and of course the legal basis and the data subject rights. So right to access, etc., etc. So this is like information, be transparent there. Then purpose limitation. If you collect data for certain purpose, it can't be used for any other purposes in principle. So, and if you want to use it for certain other purposes than you originally have informed and collected it, you in most of the cases you should have the consent from the data subject, or at least in certain cons. So it's like should be used where it collected or meant to be used originally. Let's say that. Minimization of data means that you should process as minimal amount of data as possible. Do not process any unnecessary data. So all data process should be necessary for the purposes it's collected. And this, like, sometimes it would be good to have more data, but actually that's not one of that's totally against the principles if you can't verify the actual purpose. Then the data should be accurate, so up to date. That's sometimes hard, but of course you could, if you have sophisticated information systems, etc., it should be done. Storage limitation is something which at least now should be done or defined. So how long you will keep the data. The data should not be kept in any situation longer than it's actually needed. And of course, there are some laws applying which say that you have to keep for a certain time. But in most of the cases, there might not be a certain law saying, then you just have to define how long. And GDPR doesn't have any years, so you have to define it by yourself. And then the confidentiality and security questions. And from here, so in addition to follow the general principles, what is always should be considered, whatever you do with personal data, that you have a legal basis for the processing. So it has to be based on one of these 6 bases. And I think the most relevant normally are that you have a contract with the data subject, that somebody has agreed to order some services or to be part of some services or to order some product, etc. So you have a contract and you have to fulfill the contract. Then it's the legitimate interest. So it's normally if you represent the company, so you might have some additional needs for processing the data, not coming directly from the contract, but necessary needed for your processes. One example here, which is also in the GDPR, is the direct marketing, for example. But you should always have what they call a balance test between the data subject and the company, so that the company's interest is kind of stronger than the data subjects, and you do kind of don't process it, once again here, unnecessary. And then of course legal obligation, if there is a law which says that you have to collect. For example, in health sector, there are laws which say that you have to collect certain information. But if you go out of this, there is no in some of the cases at least, or most of the cases, there is no legal obligation if you talk about providing different kind of services. Then, of course, protection of vital interest and exercise of a public authority, but these are kind of emergency situation or public authority. If you come from public sector, of course, then these apply. Today we talk more about like the private sector point of view. And I always say for the last is the consent, because using consent as a legal basis for processing is always, hopefully, the last one you need. It should be and would be good to have any other basis, because based on the consent, you have always the problems how to take the consent and how to keep the consent. But of course, we notice that in certain cases, you have to take the consent, but do not have consent as the main basis for your processing. Use it where it's needed. And now, for example, health data is one of those questions. Please, Ville.
Yes, thanks, Markus. Yes, few words about processing of health data. As Markus already said, you have to have always valid legal basis to process any kind of personal data. But when processing personal data, it's good to keep in mind that there are some extra requirements under the GDPR, because personal data, health data, or data concerning the health status of data subject is included or is classified in so-called special categories of personal data under the GDPR, meaning that that kind of data is more sensitive than normal or basic personal data. And under the GDPR, as a main rule, processing of health data is prohibited unless there are specific legal basis for the processing. So when you are processing health data, in most cases you can't use the same legal basis than Markus said on the previous slide. For example, processing of health data is in most cases it's not possible based on contract or your legitimate interest, and in most cases you need a consent for the processing of health data, especially if we are talking about commercial solution, for example, application which collect certain health data of a user, then you need a consent. And you cannot ask consent as a part of your contract terms or privacy policy terms. Consent must be explicit, and it must be based on an active measure by a user. So user must, for example, tick the box or other way actively give the consent. And it's good to keep in mind that a data subject has always right to withdraw the consent. And when we are talking about health data, it's good to remember that the legal definition of health data is quite broad. Health data includes all kind of information of person's physical and mental health, and also information relating to the use of healthcare services if that data reveals a person's health status. For example, my medical records are health data, and for example, if employer process sick leave notification, that usually that kind of document includes data of health status of data subject. And other example, if for example, if there is an app that collects certain physical information of me, for example, my heart rate and speed when I'm doing a sport activity, and combine that data to other my personal data and analyze it medically, and for example tells me that my heart rate is good and my blood pressure is bad, and so on, that kind of data include data of my health status, and it's then classified in special categories of personal data. And usually, for example, if we are talking about that kind of applications, a consent is needed to process my health data. Of course, there are some other situations when a consent is not needed. There are also other legal grounds to process health data under the GDPR. For example, I already mentioned an example about the employer which process sick leave notifications. Employer doesn't need a consent of an employee to handle sick leave notifications, because under the employment legislation there is a right for the employer has right under the employment legislation to process sick leave notifications. But if we are when it comes to the commercial solutions and applications for the consumers, usually a consent is needed to process health data. And it's good to keep in mind that usually, for example, legitimate interest is not a valid basis to process that kind of data. A few words about the documentation. Markus already mentioned accountability principle and the main rule under the GDPR that a controller and processor must be able to demonstrate the accountability. And proper documentation is one of the key elements to demonstrate compliance with the GDPR. And here is the list of documentation that is, based on our understanding, widely used among the controllers and processors. It's not exhaustive list of documents. But first of all, controllers and processor must always have an up-to-date information, what kind of personal data they are processing, what purposes the data is processed, how long the data will be stored, is the controller or processor sharing or disclosing the data with any third parties, is the data transfer outside the EU. And in order to have that kind of up-to-date information, it's good to have some kind of data mapping document, for example, an Excel files where you list this kind of basic information about your processing activities. And Markus already said transparency principles, and the main rule that when you are acting as a controller, you have to inform data subject about the processing activities. And in order to fulfill that principle and the information obligation under the GDPR, it's usually a controller have an privacy policies and privacy notices on the websites, and it's, I would say, one of the most used way to inform data subjects. And
Ville, may I say here that like it's good to remember here just that regarding the privacy policy, that it's the obligation of, as you said, the controller to keep and inform. So if you are a processor, if you just provide a service to somebody else as a processor, it's not your obligation. It's always the controller's obligation to inform the data subjects, as well as, for example, get the consent, what Ville was talking about. Just to remind, because it's sometimes like, and have to say here, so also that it's really important to define also in the relationship who is controller and who is processor and which role you are. And regarding the documentation, most of these apply to both parties, but for example, privacy policies and the information is mainly the obligation of controller. So just to like remind this, because these are also the questions which should be like mapped all the time, in which role I am. So please, Ville, I think we don't have time to go all this through too carefully, but like just Ville can point out some examples what would be good to do.
Yes, and when I'm talking about the cases, you will see that how important this documentation is if we are talking about the accountability principle. And the third point, if you are acting as a controller or processor, and if you are sharing the data with other controllers or processors, or if you are in a joint controllership relationship with any third parties, you must always have a written agreement regarding the data transfers. And if you are sharing data outside the EU, there are also some extra requirements regarding the data sharing agreements. Markus will talk more about that. And in order to demonstrate the compliance, it's good that you can demonstrate that you have implemented also some organizational measures in order to secure the personal data that you are processing. And in order to do that, it's good to have some kind of security instructions and data protection instructions for your staff and other stakeholders that are participating in the data processing activities. And in certain situations, GDPR requires so-called records of processing activities documentation, which is a little bit similar than data mapping documentation. Records of processing activities documentation is an obligation both for controller and processor. And in that documentation, you have to, for example, list what kind of personal data you are processing, what purposes, how long the data will be stored, and are you transferring that data outside the EU. And it's good to, there is also an Excel templates on the website of the Finnish data protection authorities that you can use to draft your record of processing activities documents. And in certain situations, GDPR requires risk assessments called data protection impact assessment. There is one case which will deal with that application. I will talk more about that later. And if you have a data protection officer or data protection team in your organization, it's good in order to demonstrate the accountability. It's good to define the role and responsibilities in writing, and also the activities of your data protection data protection officer is good to be documented. For example, if the data protection officer report to your management about the data protection matters and issues in your organization, it's good to do that in writing, so you can demonstrate it later that data protection issues has been taken account in your organization. Do you want to add something, Markus?
Yeah, but just like to point out that if we talk about health sector, for example, also the private one, so health data is considered to be like sensitive data or specific categories of data. And I would say that, for example, those data protection impact assessments should be done more often than they are actually nowadays done. So it's good to and it's nothing too complicated, and it's good that you have to analyze carefully there what you are actually doing. And just to summarize that, by having this kind of documentation and analysis, you also have to go through carefully enough how you process your personal data. By having all these, I can't guarantee, but I can say that you quite well already fulfill all requirements under the GDPR if you can answer all the questions and you have all these done.
Exactly.
Please, Ville.
At least you are on more safe side then.
Exactly, that was well said.
Yes, then some recent case law, mainly from Finland. But first, a little bit about the numbers. As Markus already said, GDPR has been now in force almost 3 years, and since 2018 there has been more than 550 GDPR administrative fines cases in the EU. And just to underline the importance of issue, it's good to we just pointed out a few numbers about the GDPR sanctions. In last year, the administrative fines in the EU were more than 150 million euros, and the largest administrative fines was targeted towards Google, about 50 million, British Airways about 22 million, and Marriott hotel chain about 20 million. And these big cases, for example, those related to the use of cookies and data breach situations. And in Finland, also our data protection authority has imposed few administrative fines about 10 times since the GDPR came to the force. And in addition, our data protection authorities and also other data protection authorities in Europe have also imposed other corrective measures and sanctions than just administrative fines. It's good to remember that administrative fines are not the only option for the authorities. There are also a lot of other sanctions. For example, authorities can order to delete personal data if there is no valid legal basis to process it, or they can order controllers or processor to stop processing or give a written warning. So administrative fines is just one sanction measure for the authorities. Then a few cases. few recent cases. That the first case related to the information obligations of the controller. There was a Finnish company which collected information of its customers, consumers, and processes it for the certain purposes, but at the same time that company also disclose and transfer to that personal data to third parties for direct marketing purposes, and the data subject receive direct marketing from the third parties. But they didn't tell very comprehensive and very clear that they are their aim is to disclose the data to third parties for direct marketing. And in addition, they didn't inform very clear about the data subject right to object the processing for direct marketing. It's good to remember that under the GDPR, data subject has always a right to object, in other words, ban processing for direct marketing. And because the information was not comprehensive and it wasn't transparent in authorities' view, as a conclusion, the authorities considered that the company was failed to comply with the principle of transparency and the information obligations under the GDPR. And because this violation affected quite large amount of consumers, about 161,000, the administrative fine was quite big, 100,000 euros, and it has been, if I remember correctly, the largest administrative fine in Finland so far. But here, the essential issue was that the information must be done clear and comprehensive way, and it is crucial that data subject really understand and that what are the purposes the controller is collected, the data is collected for. And then the second case related to data protection impact assessments, which was mentioned on the slide concerning the relevant compliance documentation. Data protection impact assessment is a risk assessment stipulated in the GDPR, and Markus already said that it is usually required, for example, if an organization is processing special categories of personal data, for example, health data. And in that case, a company acts as an employer and it processes a location data of its employees by tracking vehicles of employees. And the location data was used to monitor working hours. But in this case, basically it wasn't a problem to use such location data to monitor working hours. It was fine, but under the GDPR and under the guidelines of the European Data Protection Board, a data protection impact assessment is needed if a controller is processing a location data, and if the location data is used for systematic monitoring, and if the data subject which are under the monitoring are in disadvantageous position comparing the controller. And in this case, the authorities came to the conclusion that tracking vehicles in order to monitor working hours means a systematic monitoring of based on location data. And in addition, the authorities came to the conclusion that there is a clear imbalance of power between the employer, who was the controller, and the employees who were the data subject. And for those reasons, a data protection impact assessment should have been done, but the company had not done the data protection impact assessment before it started to process the location data. And because the data protection impact assessment document was missing, the authorities conclude that there is a violation. There was a violation of the GDPR, and they impose an administrative fine towards the company. And the third case, it was the issue here was collection of unnecessary personal data. The company acted as an employer, but for some reason it collected certain unnecessary personal data of its employees. It's for example, it collects information concerning the health status, pregnancy, and family relationship of the staff. And under the employment law, there is no usually reason, and there is no right to collect that kind of information if you are acting as an employer. And in addition, as already said, data concerning the health status, for example, is categorized in special categories of personal data, and it needs and there is some extra requirement to process that kind of data. And in that case, the authorities came to the conclusion that the company there was no valid legal basis to process that kind of data. And in addition, there was a clear violation of the act on the protection of privacy in working life. And in addition, some relevant essential privacy documentation was missing. For example, the company did not inform why they are processing, why they are collecting this data. And as a conclusion, data protection authorities conclude that there was a violation of the GDPR mainly, and the main reason was that there wasn't a valid legal basis for the processing. So always when you are planning to collect certain personal data, it's important that you define the legal basis, and you in advance before you start the processing, and you collect only a minimum amount of data in order to meet the purposes. And the fourth case relating to the electronic direct marketing, Markus already said that we have an Act on Electronic Communication Services, which, for example, regulates the processing for electronic direct marketing. And as a main rule, if you are doing electronic direct marketing, for example, sending marketing emails or text messages, you need prior consent from the data subject to do that. And in this case, the company sent electronic direct marketing emails without a prior consent. And in addition, so there wasn't a legal basis to do that, and there wasn't a legal basis to process the data for the electronic direct marketing. And in addition, the company failed to comply with the rights of the data subject because they didn't respond to the request of the data subject when the data subject contacted the company in order to ban the direct marketing. So the recipient couldn't stop the direct marketing, and as a conclusion, the authorities impose an administrative fines because there was not valid legal basis, because the consent was missing, and in addition, the company had not implemented data subject rights in a correct way. So from this case, it's good to remember that you have to have always an internal procedure how to implement data subject rights. For example, in a case when a data subject wants to object the processing for direct marketing or ban email marketing, you have to have some kind of procedure how to implement these rights in practice. And the last case relating to use of cookies, as Markus already said, the Act on the e-privacy mainly regulates e-privacy directive, and our national law mainly regulates the use of cookies, but also GDPR relates to that topic, because if you are using cookies other than strictly necessary, you need a consent that has been asked in accordance with the GDPR requirements. And in this case, the company used cookies on its website, but the company did not ask a consent in accordance with the GDPR. The company just informed users using cookie banner on a website that we are using cookies for certain purposes, for example, personalization and advertising purposes, but there was no option to give a consent. And according to the authorities, if you are using other than strictly necessary cookies, a consent must be asked in accordance with the GDPR, meaning that the consent must be explicit and active measure by a user. So, for example, the user must tick the box, or there could be a button that I accept cookies. But it is important that there must be an opportunity to choose whether or not accept the cookies. And other cookies, only strictly necessary cookies can be installed before user has given the consent. And strictly necessary cookies means basically the cookies that are needed in order to needed for the technical capabilities to provide the service. But for example, analytical cookies or social media cookies and marketing cookies need always prior consent, which must be compliant with the GDPR requirement, and the consent cannot be part of the contract terms or privacy policy terms. It must be an active and explicit measure given by the user. So here were the cases, and as a conclusion, I would say that these cases underline the importance of the main principles that Markus already presented, and those cases also underline the importance of the key compliance documentation, such as privacy policies, data mapping documentation, and data protection impact assessment, and also underlines that always when you are processing data for any purposes, it's important that you have determined the legal basis in advance. And now Markus will say a few words about the data transfers and the current situation on that field. Please.
Yeah, thank you, Ville. And I think that is like good summary of the last year decisions by the authorities. And in addition to this, I just want to mention that not maybe in Finland that much, but worldwide, I think we didn't have any cases here regarding the security questions. But of course, if you go through the cases and all those 550 or whatever, so you can also find that in quite a big amount of the cases are around data security. So the technical and organizational security questions.
Data breaches.
Data breaches, yeah. Thank you, exactly. So, and based on that, there has been data breaches. So please consider, and especially when we talk about health data, of course, data security is one of the key questions, and which is one of those causing also, of course, data breaches most harm. But please, we can talk about data breaches another time, and now about transfer of personal data out of the EU, EEA. We talk mostly with Ville here out of the EU, but in reality, of course, it's the whole European Economic Area. So in addition to EU countries, there are certain other countries which also are governed, and you don't have to consider to use any additional mechanism. But anyway, so the main principle here, is that if you transfer personal data outside the EU, you need to do something extra, or you have to be sure that there is the country you are transferring the data is safe enough. And there are few types from a country to be what they call under an adequacy decision, so considered to be safe enough. And there is a quite brief list of those countries which are considered to have the sufficient level of data protection, so include from Argentina to Uruguay, etc. And this is once again, it's the list, and no other countries are so far considered. So something else has to be done. So you need some mechanism, some additional measure to cover the transfers. And it comes later, but when I'm talking about transferring the personal data out of the EU, it includes also all kind of access from outside of the EU. So it's not that you concretely send a list of names, but if somebody has access to any of your systems out of the EU, EEA, so that this applies also. So the GDPR says that if it's not under adequacy decision, then you have to do something else. There are a few possibilities. What we talk shortly is like standard contractual clauses accepted by EU Commission. So these will be as a part of your agreement with the other party. This applies to all relations between two controllers, or the controller-processor relationship overseas or out of the EU. Then there are what they call binding corporate rules, which some of the bigger companies have internally or apply internally, and then all kind of conduct certificates, etc. But I think the standard contractual clauses is what you should remember here. mainly. And some, of course, there are some derogations, and you might, but I would say that these apply only in practice, not too many in not too many situations. And what, of course, you can always ask is the explicit consent. And of course, there are some situations where it doesn't apply. So regarding patient information and employer-employee relationship, there are certain specific rules. But as a general law, by consent, you can also transfer. But it's maybe you can have the explicit consent easily from one or two, but if you have application and you should be compliant with all the consent rules and have explicit consents and be sure that they apply, etc., and have consent for that. And this is always all where you need consent. All the consent should be taken individually, not as a part of the privacy policy or as a list that, hey, I consent to all these kind of things. So in practice, it makes it almost impossible to handle the consent processes. Of course, sometimes it's possible. And of course, when we talk about health data, if you need a consent for processing health data from the beginning, then you have already based on consent. And then, of course, you need also an additional consent for transferring it out of the EU. Good to remember, as Ville said, it's the problem that, of course, you can always withdraw the consent, and what happens then, but that's the next question. But what is quite important here, what is our message, is that between certain countries like EU, United States, there was some certain mechanism which helped the processing and not to implement any additional measures. But fortunately or unfortunately, already last July 2020, there was this famous Schrems case, which says that actually the privacy shield mechanism is not valid. So actually, what is latest to be done now is to check that your processing out of the EU is not based on Privacy Shield. This is, of course, Privacy Shield was only between EU, US, but it was very important. And I think there was like tens of thousands of companies also from the US side, was it 50,000 companies implemented or part of the Privacy Shield. And now we don't have that kind of mechanism, so something else has to be done. When we are reviewing the privacy policies, we still see Privacy Shield as one of those mechanisms used there. So what should be done now? So it's already old rule that if you transfer, it's nothing new. If you transfer data out of the EU, something has to be done. And you should maybe once again start from reviewing what is happening, where you are transferring data, or what kind of service providers you use. Are they located out of the EU, including all these bigger systems? Sometimes if you use whatever US-based CRM systems, etc. So they are located out of the EU.
And document those transfers to your data mapping documentation or record of processing activities documentation.
Yeah, and then show that data mapping and records show them and do it carefully, because it happens also in the bigger companies that actually we didn't realize that one of the service providers is actually from the US or somebody else, or from out of the EU, or they are from the US, but we still have used Privacy Shield as a basis for the transferring. So something else has to be done now, and what is actually the most recommended way to do it is implement those what I already mentioned, so the EU Commission standard contractual clauses. If you are not familiar with those, please, there are a lot of information on the Commission's on the official authority sites, and also the Finnish Data Protection Authority has some guidelines regarding the standard contractual clauses. Unfortunately, these are also under construction at the moment, so they might change, but anyway, use those as they are now, and they should be part of your agreement. In most cases, if it's a processing agreement with the data processing agreement, or if it's between two controllers, so maybe as an additional document securing the relationship. The difficult question here is, of course, that the case 2020, the Schrems case, it also said that these standard contractual clauses, SCCs as they are called, are in certain cases they are not enough. So you need supplementary measures. And so you have to add certain clauses, certain analyses to be sure that the transfer of personal data is considered to have a sufficient level of data protection. Part of that is contractual. Part of that might include even auditing the partner to be outside of the EU. We know that in certain cases it's impossible, but anyway, so you have to now analyze what's happening regarding the transfers. There are two actually recommendations which are good to follow and check. And from the recommendation, for example, which is like 01/2020 here, so you can find examples of cases. So different kind of transferring cases, you're transferring rights or somebody has access. There are different cases saying what kind, showing that what should be done, and in what situation even it's impossible to have a sufficient level of data protection, and list of supplemental kind of at least contractual clauses to be added to amendment the SCCs. So there are not exact lists, and you can't provide at the moment exact list what should be done in all cases, and this is all, unfortunately, it's case by case. So every transferring out of the EU should be analyzed separately, and then probably do something additional to protect to have the sufficient data protection level there. In practice, if you have a processor out of the EU, you should already have a DPA, so data processing agreement with that party, and it's a quite standard text. It should be referring also the SCCs. And as such, it was done, for example, a year ago. It's not enough. And you should probably, as I already said, have some kind of amendment there where you can show that you have analyzed the situation more in concrete, and actually required more obligations from the processor out of the EU. For example, analyzing the situation of legal environment in certain countries and report if there are certain surveillance laws, etc., applying. Are these enough, and will this in practice at the end of the day protect the data subject? That is more like political question, but our message is here that you should really to analyze all those situations. If you're using, for example, US-based CRM systems, etc., most of the bigger companies, they have implemented some kind of supplemental measures also in their policies and DPIAs. But anyway, be careful there. And unfortunately, the authorities are very nice here. They say at the end of the day that if you can't guarantee and if there is no supplementary measures available to ensure the appropriate level of data protection, then processing must be suspended or ceased. So sometimes it's time maybe to change the processor, your service provider, or analyze, is it okay still to transfer out of the EU? And this was, we talk from, the case was on the privacy shield and the US, but of course this applies, just to like show the map, so this applies to all transfers out of the EU. So thanks to Brexit, it was the UK, for example, was to be considered as a third country, as they say, but now there is this, is it called transfer period until the end of June, when UK is still considered to be adequate and nothing has to be done so far regarding the processing, regarding the transferring to UK. And there is the adequacy decision pending now in the EU, and hopefully it will get out from there before the end of the June, and it might be possible that UK, and I think politically it will be so, that it will be considered to be adequate, and actually no additional measures between EU and the UK has to be done. But then there are a lot of other countries where you might have business, and just to the end, that it's good to remember that all these out of the EU countries, they do also have their own privacy regulation. And for example, India is just implementing a new one. You should also know that if you attract customers from those countries. So this was our brief webinar about basis, what has happened during the last year in Finland, and the transferring of data out of the EU. We are 8 minutes behind. Thank you for everybody following us, and hopefully everybody enjoys the rest of the week and the rest of the winter, and already waiting for the spring and waiting for some better times regarding the one big question we still have here. But be careful out there and try to manage in the jungle of data protection.
Thank you also on my behalf, and wish you a nice day and nice spring. Stay safe.